The U.S. Supreme Court is likely to rule on President Obama's health care law during the election year. Conservatives argue that the law is unconstitutional. They say the government cannot require people to buy health insurance. The court has set aside 5.5 hours for arguments. Normally, it allows only 1 hour split between the two sides. For more on this important story, let's go back over to Pat.
Thanks, Lee. Well, we have with us a good friend and a key constitutional lawyer, Jay Sekulow of the American Center for Law and Justice. Jay, are you happy that the Supremes have taken jurisdiction?
I am. I'm happy that it's going to finally be adjudicated where it should have been probably a year ago, and that's at the Supreme Court of the United States. Pat, they've taken every issue that has been raised. You know, we're representing 105 members of the United States Congress. I think it's actually up to 106 now. And also, there's been a series of challenges in Florida. We've filed in that case. We brought a case in the District of Columbia that is now on its way to the Supreme Court. It will be held with this case. There's cases coming out of the Fourth Circuit. But it's not an ideological split as normal. For instance, Pat, in the 11th Circuit case, we carried the day because a Clinton appointee came with us and took the position that we were advocating. Yet the 6th Circuit and the District of Columbia Courts of Appeals went against the position we were advocating, and Republican nominees signed on. So there's a lot of issues at play here. It's not going to strictly be ideological lines as normal.
Jay, they've got several things. One, of course, is the issue of severability. If they take that individual mandate, does that kill the whole law? Usually, there was nothing in that bill that says it's severable, so you'd think that was the linchpin and it would take the whole law down, but that's the key. They also understand there's an issue of standing, whether the people making these complaints have standing to come in on a constitutional issue like this. Are there any other issues they'll be dealing with?
Well, the biggest one is going to be, of course, the individual mandate, which is not a surprise. That was the requirement that you must buy this insurance or face these penalties imposed by the Internal Revenue Service. But the second thing, Pat, is the Anti-Injunction Act, which goes into your first point about standing, and that is are these cases ready for adjudication because the bill has not yet gone into effect? It's imposed through the tax code, and there is an Anti-Injunction Act. And that could be a very close issue in this case. So it is conceivable that after 5.5 hours of oral argument, hundreds of pages of briefs that are going to be filed in this case, that the court simply says, challenge interesting, but we're not going to look at it till 2015 after this law is really in effect. So there's a significant hurdle here that has to be hopped over. But the fact that they gave 5.5 hours for oral argument over a 2-day period, I think is significant. I think that speaks definitely to the seriousness of this case, but predicting the outcome of this one, very difficult. I will say this, regardless of how it goes, if the court decides to strike it as unconstitutional, that is a victory. If the court decides to leave it in place and says it is constitutional, you're talking about probably the most significant election issue of 2012, because it would take a Republican House, Senate, and White House to get rid of that legislation.
What about Justice Kagan? She was a Solicitor General and actually defending this law. Shouldn't she recuse herself?
You know, recusal, Pat, is completely up to the individual justice. There's been a move to have her recuse herself. There's been a move to have Justice Thomas recuse himself. My real consensus here is neither will be removed. She has stated that she was not substantively involved in the litigation. There is that email that came out where she was glad it passed. But that is really their call, and there's absolutely no indication that either of the justices will, in fact, recuse themselves. In fact, you would have probably seen that in the order, because oftentimes when certiorari is granted, that is when the court decides to hear the case, they'll say, you know, such and such justice decided not to participate in the determination whether to take the case. That was not noted here. So my suspicion is we will have 9 justices determining this. The arguments will be in March. The decision will be in June, and an election in November. And, Pat, you know the election issue is going to play very, very significantly.
Paul Clement, I suppose, will be arguing for the people who are opposing the law. Are you going to be involved in any of the oral arguments?
We're going to be helping Paul. We're not going to be, he's representing Florida here. The cases that we've had in chief are at the just coming out of the Court of Appeal stages. So those will be held at the Supreme Court. Paul Clement will be making the primary argument on behalf of the states. The Solicitor General for the United States will be doing the argument on behalf of the United States. We will be filing actually briefs on behalf of most of the Republican leadership. I think all of the Republican leadership at this point, or certainly most of it, and about 105, 106 members of the United States Congress. So we're going to be filing a very significant brief. The argument in chief will be made by Paul Clement, who, as you know, has been down to Regent before, former Solicitor General, a very good friend of ours, and will do a fantastic job. And the Solicitor General's office will do a job. This is going to be a case to watch for oral argument skills. But at the end of the day, a case like this, the briefing, oral arguments are great. They're always important. It's the fun part of the case. But you usually win or lose these on the brief. So the work is starting, literally, Pat, started yesterday at 10:01 when the court said certiorari is granted. And everybody's to work here. It's going to be a lot of briefs. We'll be filing a number of briefs on a whole lot of issues because the court has taken everything. Every issue that's been raised has been accepted.
Well, Jay, thank you so much, and best wishes on this case. And ladies and
Thanks,
gentlemen,
Pat.
it